Yeah, it's great to be back here, and by here I mean here at Harvard, since this building didn't exist when I was here in class of '96. So today I'm going to talk about privacy and utility in data sets, and let me explain a little bit what I mean through a little story. Many of you may be familiar with this story, and this is the story of the Netflix prize. So in about a few years back, Netflix decided to run a contest, and the idea behind this contest was to try to improve its movie recommendation systems, right? And so they offered $1 million to a team that could improve the movie recommendations by at least 10%. And after, I believe, about 3 years, this team, Belcore Pragmatic Chaos, won by improving this algorithm by 10%. So they won the $1 million, collected the prize. And you know, it all seemed good for Netflix on that side of things. But meanwhile, while these teams of researchers from Bell Labs and other places were working on the machine learning problem of trying to improve movie recommendations, a pair of researchers at the University of Texas worked on a somewhat different problem. And the problem they worked on was to try to figure out who was in the database of movies that Netflix had released. Because after all, in order to design one of these recommendation systems, you had to have the database of previous ratings of a bunch of customers. And then they tested these new algorithms against additional ratings that these same customers had made. All, of course, without, in fact, revealing who these customers were in the sense of revealing their names or something of the sort. They just replaced names and other similar kind of identifying information with just some sort of ID number. But of course, you had to maintain consistency across an ID number, right? And this only makes sense if you think of each individual as having one record and knowing what all of their movie ratings and rentals actually were. So what the researchers from Texas figured out was that it took only a relatively small amount of information in order to identify who any given individual was in this database. It was the sort of information that they thought, you know, you could just find out just by talking to someone casually at a cocktail party or the like, or sometimes be able to figure out by looking at which movies this person had publicly rated on IMDb, on the Internet Movie Database, right? That by publicly rating some movies on IMDb, individuals would give up enough information that then their record could be picked out of the massive Netflix database. And if, for example, they were willing to rate and review some movies publicly, but wanted to keep others secret, right, that privacy now was broken. Okay? So that was the result that the researchers from Texas came up with in this case. The Netflix wanted to have a sequel to this contest, but it ended up being scrapped. They ended up coming under investigation by the FTC. There was a lawsuit filed against them as a result of just this first contest. And there seem to be no plans to now introduce a Netflix prize too. So the question is, what are we to learn from this story? And there have been other stories that have been in a somewhat similar vein, but I think this one is perhaps the most striking of them. And I'm going to tell you a little bit from the perspective of the law and policy folks about what folks have been saying with respect to these kinds of re-identification attacks and the like. So the most recent round of thinking about this problem was largely started by Paul Ohm, who's a law professor at the University of Colorado, who wrote a couple years ago, "These studies and others like them sound the death knell for the idea that we protect privacy when we remove personally identifiable information from our databases. This idea, which has been central to the focus of information privacy law for almost 40 years, must now yield to something else." Right? So the notion is, look, this shows that we just can't expect to anonymize data. If we want to protect privacy, we need to do something other than try to anonymize the data. Okay? Jane Yakovitz, who's now at the University of Arizona, has written, and she, along with a number of other commentators, has basically taken the opposite view. The focus of influential computer science literature is preternaturally consumed by hypothetical risks, and legal scholars have come to alarmist conclusions about the current state of data sharing. As far as she's concerned, look, there are these few examples out there, but we shouldn't make much of them. If anything, we actually should be encouraging more data sharing rather than less. And we should be relying upon existing tools in order to anonymize data in a good enough way, anonymize data in a way that will be good enough for the kinds of studies that we want to do, and that also protect privacy in a kind of good enough way. Okay? So these are the sort of competing poles that have developed with respect to this question of whether or not anonymization is this kind of thing that we ought to be recognizing in law and policy going forward. So what I want to convince you of is three things. I want to suggest first that we shouldn't be too pessimistic about anonymization. But second, we shouldn't be too optimistic about it either. And third, and perhaps most importantly, there are critical questions here that lie entirely outside of the computer science that lies behind both of these claims and both of these results. And I want to try to describe some of the dimensions of this problem, trying to think about ways we can start to think about this problem going forward that don't really align with either of the two poles that I've just described. OK, first, why shouldn't we be too pessimistic about anonymization? So Paul Ohm has claimed that computer scientists, that is to say many of you, have proven theoretical limits on the power of anonymization such that the utility and privacy of data are linked. And so long as data is useful even in the slightest, then it's also potentially re-identifiable. In other words, you're never going to get useful data unless it's also unprivate, right? That's the claim. And he points primarily to this paper by Justin Brickell and Vitaly Shmatikov from 2008, in which he and reproduces this very graph in the law review paper that he wrote, and says, look, the black bars represent the loss of privacy from a given data release. The gray bars represent how useful this same data release actually is. And as you can see, every time the black bar shrinks, the gray bar shrinks, more or less in proportion, in fact, right? So the conclusion that one is supposed to draw from this graph is that, in fact, you cannot gain any privacy without losing a sort of corresponding amount of utility. Okay? That conclusion, however, I want to suggest is far overstated. Okay? And in order to understand why, let's think a little bit. Let me tell you a little bit about what actually these black and gray bars represent in this particular paper. Okay, so here's the model. The model of Brickell and Shmatikov is that we've got Q, a set of quasi-identifiers which are known to the adversary, the entity that is in fact trying to break the anonymization, trying to break privacy here. And in this particular example, Q was the set of age, occupation, and education. S, we have some sort of sensitive attribute. In this case, it was marital status, chosen just for reasons of the particular database here and not for reasons of its actual sensitivity. And what we need to know is how do they actually define the loss of privacy on the one hand and the gain in utility on the other, right? So loss of privacy here is defined as the gain in the adversary's ability to predict the sensitive attribute given knowledge of the quasi-identifier attributes. I've written the equation up here, but basically the way to read the equation here is that knowledge of the quasi-identifiers, right, allows the adversary to effectively break the release database into equivalence classes, into sets as to which the adversary sort of would treat them as functionally equivalent. In other words, all the folks that share the same quasi-identifier attributes, right? And what the adversary is going to do is going to predict each one of those individuals with whatever sensitive characteristic is most common in that equivalence class. Right? And so what we do is we sum over all the equivalence classes and compare that to what the adversary would be able to accomplish if they were only predicting what was most common across the entire population. Right? And so that gain in knowledge, as it were, is the loss of privacy, is how loss of privacy is being measured here. On the other hand, how do they measure utility? Right? In this particular case, what they were interested in is utility of this data for data mining purposes. And so what they did was to ask, how good would a classifier be, a data mining classifier, right, on this data set where we are trying to use this classifier to predict a particular attribute, okay? A particular attribute either given the full data set or a particular attribute given just the sanitized data set, as it were. And that difference is the difference in utility that they measured here. Okay. But crucially important here, right, is the question of what sort of classifier are we trying to build in this particular example. It turned out that in this particular example, the goal of the researcher was to build a classifier that would predict marital status. That is to say, exactly the sensitive attribute that we were trying to hide from the adversary, right? So it should come, indeed, as not much surprise that, in fact, if you sanitize the database such that you essentially break connections, right, between the other data, in particular the quasi-identifiers known to the adversary, and the sensitive attribute, you are also, in some sense, breaking the ability of a classifier to be able to take this large database and properly predict, again, exactly the sensitive attribute, in this case, marital status. And that also explains why the black and gray bars shrink and grow with uncanny proportionality, right? It's not even just that one shrinks when the other shrinks. I mean, they shrink almost exactly in proportion, and that is exactly why. Okay, and just to be clear, the far left here is releasing the full database. Everything else is some form of, quote, anonymized database. This same paper actually does, in fact, test a situation in which the classifier is aimed at something different, right? In which the classifier is aimed at what it called a neutral attribute rather than trying to predict the sensitive attribute that you're trying to hide from the adversary. And in that case, actually, the results are much more equivocal. Again, for technical reasons, the absolute heights of these bars are completely irrelevant. All we want to know is whether or not we can make the red bar shrink, right, gain privacy, while not losing too much in one of the other bars. And actually, if you look across this graph, you can find several instances, particularly in the columns labeled T, where, in fact, we seem to have gained substantial amounts of privacy without, in fact, losing the particular form of utility that we were looking for in this particular case, right? Now, the specific details of this paper and what this paper does or does not represent, right, are less important than realizing that what matters here is how it is that we're actually defining the notion of privacy here and how we're defining the notion of utility, right? If we define privacy and utility in this particular way, in a way that is essentially where one is essentially the opposite of the other, then of course the two things are fundamentally incompatible with each other. But if we define privacy and utility in a different way, in a way in which what we are aimed at as a researcher is quite different from what we are trying to hide from the adversary, right, then in fact we might be able to do much better. Okay. Ohm actually also does recognize the existence of Cynthia Dwork's work and that of many others on differential privacy. So I'm assuming this is the sort of thing which is familiar to a bunch of you, but let me just briefly describe here what the notion is. So in English, the idea is that differential privacy is supposed to capture the idea that any one individual should not matter very much in the database that is released, right? To the extent to which you are trying to invade one particular person's privacy, that person's inclusion or exclusion from the database ought to be largely irrelevant. That takes care, in some sense, of the situation in which you are able to use the data to figure out something about an individual. So, for example, you have some large database that tells you something about the incidence of cancer in the United States. That, in some sense, tells you something that you did not know about every individual in the United States. But it's something as to which that one particular individual is largely irrelevant, right? The information you gain here does not depend upon whether or not the targeted individual you're interested in is actually in the database or out of the database. And that intuition is what is trying to be captured by this definition, which I've given in formal terms down below. So what Paul has to say about this is that these kinds of alternatives don't make up for what he calls the broken promises of release and forget anonymization because they're less flexible. They are interactive techniques that require constant participation from the data administrator. But what Paul has missed here is the long line of an increasingly growing body of work on non-interactive differential privacy, right? Ways in which you can in fact, release not necessarily a form of the data, but at least some sort of data structure, or some sort of construct, right, that allows you to answer some interesting questions, answer, in fact, even a relatively large number of interesting questions, but only those of a particular form, while still nevertheless maintaining the properties of differential privacy. Okay, and this is an area of continuing and active research. Okay, so in fact, there are tools that we can be looking at that suggest that, again, we can maintain a certain kind of privacy while still answering, again, certain kinds of questions, right? And so one needs to define carefully both what kind of privacy we want to obtain and what kinds of questions it is we want to answer if we want to understand whether or not we can obtain both privacy and utility at the same time. On the other hand, we shouldn't be too optimistic about anonymization either. Jane claims that, that indeed what we can do is simply check for what she calls a minimum subgroup size. In other words, that when we release the databases, the groups, the sort of equivalence classes that I described before, right, are all sufficiently large such that we can then, in that sense, supposedly foil an adversary. Now, this is effectively a form of what is known as k-anonymity, right? And the idea here is that we have certain kinds of demographic characteristics which are known to the adversary. And what we do is we generalize or suppress these characteristics to create larger groups such that, again, we're sort of essentially creating these equivalence classes of size at least k so that the adversary cannot distinguish between the records in each equivalence class. Right? And so here's an example where k is equal to 2, assuming the adversary knows race, birth, gender, and zip code, assuming these are known with, known exactly, right? So, for example, the adversary knows exactly the birth date of the target individual that we're trying to figure out the medical diagnosis for. Nevertheless, we're not going to be able to distinguish, say, between records T1 and T2, right? Because even though these two men were presumably born on a different days in 1965, the database no longer contains that information, and therefore the adversary can't distinguish between these two. Okay? The trouble, of course, with relying upon this notion as essentially a catch-all for ensuring privacy in these kinds of databases is that k-anonymity has some known limitations. Right? One clear known limitation is that it's very sensitive to what's called the background information attack. That is to say, the adversary potentially knowing more attributes than you've actually accounted for, right, in whatever release database that you have. So in this particular case, it's a little harder to see, but you can imagine, for example, releasing such a database and also having information, let's say, about the date of the medical visit, right? That might be a kind of background information that will allow an adversary to distinguish between multiple records in a way that was not accounted for by the supposedly k-anonymous database. And the other problem is what's called the homogeneity attack. That is to say, sometimes adversaries can learn information without, in fact, having to distinguish between different records in the database. In this particular case, if I know that I'm interested in the medical diagnosis of someone who is a white male born in 1967 with zip code 0213 something, right? If I look at the last two lines, what I see is that the adversary is unable to distinguish between these two records in the database, but nevertheless learns that this person has the medical diagnosis of chest pain, right? And so notice here that it matters a lot how it is we're going to define a successful attack on privacy in this case, right? If a successful attack is defined as actually identifying which record corresponds to which person, then in fact the adversary has still been foiled in this case. But if a successful attack is finding out this person's medical diagnosis, then the attack succeeds. Okay? And so that again shows that reliance upon any one particular definition of privacy in this case has underneath it, right, some notion of what kinds of attacks it is that we want to foil and which attacks we think are the ones that ought to be provided for in order to be able to call a system secure and private in this way. We see this in general in a number of parts of the literature on this question of whether or not re-identification attacks are generally successful or not. Here's a sort of meta-study by Elamam and some others in which they say verification of re-identification attacks is important because even if the probability of a correct re-identification is high, the re-identification attack is not successful unless it has been verified, right? So this is a particular view, again, of what counts as a successful attack, right? It's a view that says one really needs to be sure that you can link up to a particular record in order to count this as a successful attack. On the flip side, this particular meta-study also has a particular view about what counts as useful data, right? What counts as maintaining the usefulness of the information. And again, it's not obvious from the face of the study, but more obvious once one looks at how these kinds of studies are conducted, right? This meta-study claims as its ultimate conclusion that even though the re-identification rate across these different studies is supposedly high, most of these studies were not de-identified according to existing standards, right? So again, it has a notion of what should count as the standard by which we are going to de-identify. And in this particular case, this is a reference to the standard of that's encapsulated in the HIPAA privacy rule. This is the rule that applies to medical records, right? And what this rule requires in order for information to be de-identified and therefore released without restriction under this law is that this list of 18 direct and indirect identifiers have to be removed. There are various nuances with respect to things like the ability to use the first 3 digits of a zip code potentially and not just the entire state, but this is the basic idea, right? But even if we allow, for example, the first 3 digits of a zip code, right, but not the last 2, notice that this makes certain kinds of studies impossible, right? All of Manhattan shares the first 3 digits of a zip code, right? This means that if you want to notice any effects within Manhattan, you will not be able to do so, despite the large diversity of the population in Manhattan, right? Because this particular safe harbor requires you to strip out that information, right? So again, if we're going to maintain the view that we can protect privacy while still allowing useful research to be conducted, if this is what counts as protecting privacy, right, we surely have restricted, at least in some measure, the kinds of studies that can actually be successfully accomplished. Okay? And so again, we need to be sensitive to the question of what kind of research it is that we think ought to be able to be possible given the database that we're trying to release. Okay. So I think I've foreshadowed now what some of the critical questions are here. That I think we ought to be thinking more carefully about going forward when we try to understand when it is that we should be allowing these kinds of data releases or under what conditions we should be allowing these kinds of releases. In particular, we need to think about both what we mean by privacy and what we mean by utility in the particular context in which we are asking the question, right? These are not quantities that can somehow be defined once and for all and thereby create some sort of solution that will work across the board. These are quantities that really need to be thought of within the context in which we are actually asking the questions. In particular, rather than thinking about privacy as some sort of abstract idea, we should instead be thinking about threats, right? And this is going to be obvious to those of you who are security researchers, right? We've been doing this in the security field for a long time, and of course in many parts of the privacy literature as well, right? But it turns out this is a lot less obvious to the lawyers and the regulators, and an important thing that I think is missing in this discussion, right? That the key question here is identifying what threats it is that we are trying to address, either with a given legal solution or with a given technical solution, and defining what the power of these threats actually is, and thinking about then how it is we want to deal with the capabilities of the particular adversaries that we've identified. Okay, so that's, I think, one and perhaps the most crucial step in thinking about this problem. An additional problem that we're facing is trying to think about how we should deal with probabilistic information. This is something the law actually does quite poorly by and large, trying to think about probabilities and what it means for something to be probabilistically true. There are a few notions in the law, things like preponderance of the evidence, which more or less corresponds to 51%, or beyond a reasonable doubt, which is, as far as any court has been able to say, completely unquantifiable, right? In this case, too, what we potentially have are adversaries that have certain kinds of probabilistic information, and we need to think about how it is we want to deal with that kind of probabilistic information when adversaries know something but don't know it with certainty. And the crucial missing piece here, I think, is in failing to think about this probabilistic information as itself the privacy violation, rather than being merely a risk of a privacy violation. So I'll come back to that in a minute. I'll describe that further in a moment. And finally, we need to be thinking about the different kinds of research that we're trying to support given these kinds of data sets, and characterizing those that we can actually accomplish while still maintaining privacy, while distinguishing those that will take some other solution at least some other solution than a technical one in order to maintain the kind of privacy that we want. So first, identifying threats. So in a lot of this discussion, it's easy to talk about the threat of data release as being, yeah?
Sorry, I just want to go back to the last slide.
Yeah.
So I thought looking at this, like the point of differential privacy was to deal with, in some sense, exactly these issues that you're bringing up, right? So you have to worry about trying to define the power of the adversary to come up with some threat model. Is that the history of security is people defining a threat model that turned out to not be a strong enough threat model that people just think outside that threat model and come up with an attack. And the point of differential privacy was to come up with, in some sense, the strongest possible threat model.
Right.
And to cover that entirely and say, what can we do under these settings?
Right.
And how powerful can we make it? So, I mean, I'm somewhat worried about any attack, legal or otherwise, it starts with the idea of let's define the threat model, because I don't see how that works in a security setting.
Right.
And again, that's what differential privacy was designed to establish, was to say, the inclusion of a person in the database changes the answer that needs to get in some case.
So it's obviously correct, right, that differential privacy provides one answer to these questions. But I don't think it's the only legally defensible answer. That is to say, I don't think that it's the case that the answer that differential privacy, which is to construct a very strong adversary and to regard essentially any form of probabilistic information above some threshold, right, as being problematic, are the only possible answers one can give. And in fact, the trouble with requiring those sorts of answers is that there are some quite clear limits, right, on what you can in fact accomplish while still maintaining differential privacy, right? It's not in fact possible to sort of do everything that you might want to do in a differentially private world. So now, if the answer is, well, that's all well and good, but we are concerned about the potential for threats that we have not identified, right? That's true, right? But then we're giving up something, right? And so we have to realize then what it is that we're giving up if we want to claim that the ultimate goal here is to try to maintain privacy against the strongest possible threats, the strongest imaginable threats, right, in some theoretical sense. And then we're going to see what we can accomplish. Because the fact of the matter is, in many settings, we're going to be unwilling to do that. Right? We're going to be unwilling to start with the strongest possible privacy guarantees and just see what useful things we can accomplish. And we might need to go in the other direction.
And then I guess what's missing here is under what, in my mind, is what are your settings for coming up with appropriate legal standards that don't fit into that framework?
Let me try identifying a few, and then let me flesh this out a little bit more, and then we can come back to that question, right? So in this setting, the natural tendency is to try to think about maintaining privacy as unitary across a number of different potential threats. And so my claim is that we ought to be thinking more carefully about identifying which of these different kinds of threats might be most relevant, at least for a particular setting, right? And so possible threats might be, for example, some kind of identity thief or some other kind of direct bad actor in some way. We might be worried about snooping neighbors, for example, right? We might be worried about Facebook or Google or the aggregation of data that direct marketers might actually have, okay? This last of these, well, let me just move to here. This last of these, for example, is perhaps most relevant with respect to the most recent FTC report in thinking about protecting consumer privacy, right? What's the setting that the FTC has in mind here? The FTC here is not thinking so much about the question of when should we release medical records or something of the like, right? The FTC is trying to understand when should certain companies have certain obligations with respect to data that they're aggregating, consumer data that they're aggregating, let's say collected from the web or the like, right? And so what they have written so far, for example, is as long as a given data set is not reasonably identifiable, the company publicly commits not to re-identify it, and the company requires any downstream users of the data to keep it in de-identified form, then the data will fall outside the scope of the framework, right? So in thinking about the relevant threats here, right, what's going on here implicitly, right, is that the threats here are being potentially divided into two different categories. There's the category of the company itself, and there's the category of all potential downstream users of this. And in this particular context, it's not the public that we're particularly interested or worried about. I mean, we might be worried about them, but to the extent to which we're worried about them, we've solved it by basically not allowing public release at all, right? This is a claim about what the company itself can do with the data, and a claim about what the company's, what people with whom the company has contractual relationships with can do with the data, okay? And in this particular context, we're dealing with this threat not through imposing some strong requirements of differential privacy, for example, but by requiring certain kinds of legal obligations on these particular companies, and that they have certain contractual arrangements with downstream users. Okay?
But hang on, this doesn't say anything about how they use the data internally.
That's right, right? Other than the question of, that's what's meant by publicly commits not to re-identify it, right? That's a question of its own internal use of the data. That is to say, re-identification in this context means that it's committing to some notion of not somehow breaking the system that has been imposed upon it in this way, right? There's a lot of vagary here about exactly what system is being required here, right? And again, still vagary in terms of what counts as committing not to re-identify. But we are talking about the company's own use of the data with respect to that step.
Is it your view that the point there would be met by a company that its prospectus said it would not be evil?
I think that the FTC's view would be that the public commitment would need to be more specific than that. So in general, the reason why the FTC is requiring a public commitment of this sort is because the FTC's jurisdiction in this case is grounded upon their ability to prevent unfair and deceptive practices. And what is supposedly deceptive in this case about re-identification is not the actual act of re-identification itself, but breaking the particular promises you made not to re-identify, right? And so this is specific to the FTC's jurisdiction over the matter, not necessarily with respect to the strongest possible data protection law that we might want to impose upon such companies. Yeah.
But do you see any framework where the FTC or the law can actually define what re-identification is? Because, like, if the company doesn't hold my name explicitly, I guess, does that mean that I wasn't re-identified if my name is there, but was the last letter changed? Have I been re-identified or not?
Right. See, and this is exactly where my claim is. In order to understand the content of this requirement, what we need to understand is, what is it that we're worried about? What is it that we're worried about this company doing, right? That's my claim. That in order to understand the threat here, we have to understand what is it that we think that, let's say, Google can, do wrongly in this case. And that's the framework in which we need to be thinking about it, not some notion of re-identification that will somehow fit whether it's this context or some other. Now, I'll suggest in a moment that, here, I'll put up this slide, that in general, with respect to these questions of big data, we're mixing in lots of different possible notions of privacy here, right? And that the impetus for a lot of these laws may be one of these, even though it's unclear which one of these aspects of privacy it is that we're potentially worried about, right? There's the problems of just secrecy, there's the problem of data security, integrity of the data, and also, importantly, in problems of non-discrimination or autonomy, right? Ultimately, re-identification in this context might mean something like use of the data for targeted advertising, right? It might be targeting you, right? Using your data to target you, right? And that might somehow be the notion that we're trying to build in here. A notion that might apply with respect to Google, but have nothing to do with what we're talking about with respect to medical records or the like. OK, let me back up a little. In particular, in thinking about this question with respect to Google, it also raises this question of needing to understand the different kinds of threats that might potentially come into play. I mean, so Greg, I think you asked exactly the right question in asking, is this law actually going to restrict what Google itself can do with the data, or only about the disclosures that Google or some other company, right, could make of this data? Okay, and I think an instructive point to think about is a case that I'll now describe called U.S. v. Councilman, which came out of the First Circuit in 2005. And this was a case involving the Electronic Communications Privacy Act. So this is about the privacy of emails, essentially. So not particularly related to the specific question that I'm trying to describe here, but I think helps to show this problem of trying to think about the potential uses and misuses of the data. Perhaps emphasizing Mike's point, but in any event, here's the story. So Brad Councilman was an executive at what was a predecessor of Libris, a used bookseller, right? A used book exchange, essentially. What they did was to sign up a bunch of used booksellers for this website, and then they would essentially connect them to used book buyers, right? As part of this process, they provided email accounts to all of their bookseller affiliates, essentially. And at some point, Councilman was charged with instructing IT at the company to basically, every time an email came in to one of these accounts that was from Amazon, to create a copy of this email automatically and send it to his account so that he could read through all of the emails that were being sent by Amazon to these particular book dealers and then find out what kind of deals Amazon was giving them and potentially undercut the pricing and things of the sort. Okay? So he was charged with violating the Wiretap Act, that is to say, with intercepting communications. Now, it turned out that there's a lot of definitional trouble with trying to figure out what counts as intercepting a communication, and in particular in this case, with whether or not you could intercept a communication when it was in, quote, electronic storage. Okay, in this case, it turned out to be all about whether or not it was possible to intercept communications in electronic storage because of the particular structure of the Wiretap Act. Okay? In the end, the court actually said, yes, you can, in fact, intercept things even when they are in electronic storage, because otherwise it guts the very notion of interception on the internet or on computers. Right? But there's a separate part of this privacy law that applies to stored communications, that specifically applies to communications in electronic storage. Right? So the question was, why wasn't Councilman charged with a violation of that act instead, or at least in addition to the violation of the Wiretap Act? The problem is that the Stored Communications Act contains an exception for service providers. Service providers are allowed to effectively intercept the emails that are actually passing through them. The notion was, well, they kind of have to, right? Because in fact, they're the ones processing these things in the first place. And so there's no sense in which they would have unauthorized access to the particular communications that flow through their wires, right? But what's missing here is the notion that, well, maybe they can in fact, and it does prevent these service providers from disclosing these emails, right? But what's missing here is the notion that maybe these service providers can themselves misuse this information, as was supposedly the case in this particular case, right? Essentially, this particular law provided for outsider attacks, but didn't provide for this particular kind of insider attack that was at issue in this case, okay? And so that, I think, is something that we need to be thinking about moving forward. And you can actually see it in certain cases about data release. Here's one about the release of medical records relating to partial birth abortions. And in this case, Judge Posner, in essentially quashing the subpoena that otherwise would have subpoenaed these records as part of the case about the constitutionality of the partial birth abortion ban generally, said some of these women will be afraid that when their redacted records are made a part of the trial record in New York, persons of their acquaintance or skillful Googlers can put two and two together to figure it out, right? So potentially we're worried in this case about insiders. The notion is that even if in some sense these records are sort of fairly generic to the vast majority of people, insiders in the sense of your nosy friends and neighbors, right, might know enough to be able to both figure out who you are and perhaps potentially disclose who you are to the world at large. Right? And both of those things separately and together might be problems that we want to be able to address in this particular case. And so, again, what I want to reflect on in the FTC's report is that it is separating out this notion of both privacy insiders and outsiders. But moreover, it's applying potentially different tools to deal with both of these potential kinds of attacks. Right? Outsiders are at least in part deterred, at least supposedly, by the notion that the data set is not reasonably identifiable, whatever that means. But the notion is at least that there's some technical change that's being made to the data that somehow helps to prevent outsiders from being able to attack the data. Again, whatever that means, right? That will mean, in this case, presumably revealing certain kinds of information that we're trying to hide from outsiders. At the same time, the claim here is that we're going to use law, in particular the jurisdiction of the FTC, to try to enforce certain provisions against the insiders in this case. That is, against the company itself, trying to prevent the company itself from using or perhaps misusing the data in particular ways. Right? Those two are potentially very different kinds of attacks coming from very different quarters, and we're potentially using very different tools to deal with each one of those kinds of attacks. OK. This question of identifying the threats then also feeds back into the question of identifying whether or not and to what extent we should regard probabilistic information as ultimately harmful. Now, it's of course true that differential privacy, right, is trying to essentially eliminate all forms of probabilistic information. But what it's meaning is resistance from some who would suggest that, at least in certain circumstances, that sort of probabilistic information should be regarded as unproblematic. Right? Again, the notion of whether or not it is problematic or not isn't obvious just from the fact that one has defined it as such. Right? One needs some sort of legal and regulatory context to understand whether or not we should regard that particular form of information as ultimately problematic. So for example, suppose you have 50% certainty that person X has diabetes. Now, what has been somewhat happening in the legal literature on this question is that these kinds of questions have been caught up in notions of risk, probabilistic risk. Caught up in, for example, questions of if we have a data breach, right? There's a sort of a data spill. What's the chance that something bad will happen, right? And in that sense, what it's looking toward is the notion of something bad happening, as in some ultimate re-identification that ultimately is able to tie something to you with certainty, often. Often in the case of data breach laws, right, the ultimate bad event is supposedly identity theft. Right? That's usually sort of considered the paradigmatic ultimate bad event that the data breach has created a risk of. Okay? The trouble is that what that's missing, at least in the legal literature, in a way that perhaps the computer scientists in the room think is completely obvious, perhaps, is the notion that the probabilistic information itself might already be the harm rather than merely a risk of some future harm. And it might be that harm exactly because the threats that we're talking about, right, whether they are neighbors or Google or marketers or indeed even identity thieves, all of these threats act on information even when they don't have certainty. Right? And the fact that the threats themselves will materialize, right, in the absence of certainty would suggest that the very information itself is itself a harm rather than merely a risk that some future harm will come to pass. Okay? With the result that we ought to be thinking about these kinds of harms as being effectively some sort of present harms rather than discounting them as merely a chance of some future harm. And in this regard, we have to think both upon the possibility of what is termed objective harms, actual sort of events in the world coming to pass that are against your interest, right? But also subjective harms, just indeed the feeling of being watched or known to other people and the like, right? A feeling which itself might come to pass even when others don't know information about you with certainty, okay? And that both kinds of harms potentially occur in this context, but perhaps not in every context. Yeah. Okay.
And because of that, your insurance rate changed?
Right.
So are you viewing that as a direct harm? Is it an indirect harm? I'm just having trouble how you're legally classifying
I was calling that an objective harm because something specific has happened to you. That is, that your insurance rate has changed, versus a subjective harm, which is just the perception of other people having knowledge about you that you don't want.
Right. So the subjective harm might be that just that fact somehow is how it could harm you in the future if you have to change insurance. So even if you haven't yet changed insurance.
Right, so the subjective harms could occur because just there are fear that in fact objective harms will happen later. But in this case, if we're talking about the threats not being insurance companies, but let's say your neighbors, right? That may the subjective harm may occur even without any definable future negative event. That's the claim. Okay. And so again, in this setting, we need to be thinking about how those harms would materialize depending upon what sort of context we're ultimately describing. Finally, partly the answer from those that take the poll of suggesting that anonymization is fine and always works, right, is that this kind of probabilistic information should be generally regarded as a research result rather than a privacy invasion, right? So for example, if I'm 50% certain about some person because I have identified some demographic group that has some propensity for diabetes, right? That may be exactly the kind of thing that we want to identify rather than something that we want to suppress, right? And here is where I think differential privacy is a very helpful concept in trying to understand the notion of when it is that we think something should be regarded as a research result, exactly when, in fact, the result would not change depending upon whether or not you appear in or out of the database, right? But I don't think that differential privacy is necessarily an exhaustive answer in this regard either, because I think it can be, depending again on the context, both under and over-inclusive. That is to say, we may sometimes regard certain kinds of information as privacy invasive, even if differential privacy might nevertheless be maintained. And we might nevertheless and sometimes regard information as not invasive even when differential privacy cannot be maintained in that way. Particularly depending upon what our priors are with respect to the data at issue, right? We may have priors about whether or not we think something is likely to turn into a research result in the future, for example, below some sort of statistical significance threshold. Certain kinds of identifiers, for example, as being more likely to result in research than legitimate research than others, right? And conversely, we may also have priors about certain kinds of connections being illegitimate, even if they are perfectly good, quote, research results, right? If indeed I have some way of connecting your movie rental records to medical diagnoses, right? That may be, in some sense, a legitimate statistical correlation, but it might nevertheless be regarded as somehow illegitimate exactly because we are taking both of these forms of sensitive data and trying to match one to the other, right? So the legitimacy of that kind of correlation might not be exhausted by whether or not it is statistically significant or not. So I'm not going to be able to tell you this story, but let me just sort of, in some sense, quickly note that part of the question here also is in trying to define the kinds of research that we think that we are trying to support with the different kinds of data release. A kind of research, and this question is again going to have to be asked within the context of the particular law or regulation or policy choice that needs to be made at any given time. And what we again see is that the answer can be quite different depending upon where we are looking. In this particular case, the question was whether or not all these details about a particular family in the Great Black Migration could be revealed, right? And in a different case, also by Judge Posner, he said, yes, this information could be revealed because it's an important form of research and knowledge in the world. To understand this kind of history at this level requires you to just get the entire picture in order to understand what happened to people at that time. And to get the entire picture through the lens of individual stories, not just through data about movements of individuals at that time, okay? And what I want to at least somewhat connect this to, right, is this notion of what kinds of concept classes we're trying to support with certain kinds of data release, right? Certain kinds of concept classes are relatively narrow. For example, have low, what's called VC dimension, right? And so the notion is in these kinds of situations, we may well be able to do this kind of research with information that can be, in some sense, more restricted. But when what we are trying to do is trying to describe an almost indescribable concept class, right? The concept of what it means to have lived out the Great Black Migration, okay? Then we may have a lot more trouble trying to maintain that kind of utility while also maintaining some form of privacy. And there, I think we have a much starker trade-off to make about the legitimacy of these different kinds of projects and when it is we think privacy ought to yield to this kind of work. OK, so I'll finish there. I've taken a number of questions already, but I'm happy to hear your thoughts and further questions. Yeah.
I wanted to go back to the example of the Direct Marketing Association. So
yeah.
What these people do is they often assemble lots of different data sets about your consumer behavior into one master file. And so I wonder if that is doing what you're worried about and whether that is something to be concerned about. In some cases, it does have your name in it. Some cases, it has your email, but not your name. There's different variations of what they do.
Right. So it seems quite clear that to the extent to which we think that direct marketing is a problem, no, I take that back. There are many different ways in which direct marketing might be a problem. One way might be because they're somehow amassing this information in a way that then allows them to connect it to other information and somehow identify you, literally identify you as in your name and the like as a result, right? But we might also regard it as simply a problem to have targeted advertising in the first place, right? To the extent to which we think that's the problem, then the fact of whether or not the particular database has your name in it or not is largely irrelevant. The question is really, can they effectively target you, right? And so in that context, then the relevant threat might be, can they in fact add to your profile, even when your profile doesn't contain anything like your name or any other kinds of identifiers that are maybe not even your email address or the like, right? Just contains the particular cookie that they're trying to tie it to, right? And in that sense, the relevant threat there may be one that has nothing to do with what we traditionally think of as personally identifiable information, but is nevertheless still potentially a privacy problem that we might think of as a data processing problem. That is to say, we might allow them to acquire certain kinds of information that is aggregated across all of these profiles while preventing them from adding to any one individual profile. Further thoughts, questions?
I think the example that you gave is an excellent example why we should actually make a distinction between anonymity and privacy. There may be cases where anonymity is breached but privacy is not, and vice versa. These are not identical things. And maybe in a lot of informal discussion, in advisory discussion, in many cases they are unified.
Yeah, no, I think that's right. Though I think that they're not they're not as sharply separable, right? You can't necessarily talk about anonymity privacy problems and non-anonymity privacy problems. I mean, I think that it's still too mixed up in that sense in order to separate them.
I mean, the flip side of what you're saying is, I mean, the nice thing about talking about disclosure your requirement to, intuitively, the way I'm reading the FTC requirements is you must act as if the data were not identified. And the intuitive advantage of that is you don't have to go around and enumerate for every single use case, is this a good use or is this a bad use, right? So I can imagine the legal headache of trying to tease all those out. Am I misinterpreting what you're calling for? I'm not arguing.
So right. No. So yes and no, right? I mean, so my claim is that legal headache is inevitable, right? Which is to say, I don't see a principled way of going about this that doesn't involve some need to then trying to classify different use cases, right? Let's say, in that example, what should count as the company itself re-identifying the data, right? That I think is somewhat inevitable in law and regulation. I mean, we do this all the time. We pass some law. There are ambiguous border cases, and then we have to decide on which side those particular ambiguous border cases are going to fall. And I think that's most of the time that's a feature and not a bug with respect to regulation in this area.
No, but I'm thinking, from what I can understand from your proposal is, okay, let's not think of in terms of re-identification. Let's look at given data sets, given uses, and given context to decide is this good or bad. Write a law for that. You know, and I'm just imagining running down the long list of all these things, and then you may end up with things that are very specific and very crafted to various areas.
Right. So. Right. I mean, as usual, whenever anyone calls for sensitivity to context, the obvious counter argument is that we can't account for everything, right? And that's right, right? You can't account for everything, but that doesn't mean that one needn't try to account for some things, right? And so the claim here doesn't rely upon needing to account for everything, right? It can easily be, we're going to have one rule that applies to FTC regulation of behavioral advertising, right? And a different rule that applies to, what should the HIPAA privacy rule be, right? And I think those are distinct enough contexts that we can usefully talk about what these relevant contexts are, without both gaining something over and above the existing way in which we lump all of these things together, while also avoiding the problems of segmenting things into too many little buckets in a way that makes it difficult in ways you've just described. Yeah.
You carefully explained that PII as a concept has become less relevant, and you explained that the extension of the HIPAA 18 points is equally problematic, especially for things like direct marketing, because data is not included in advance, could as a set identify you.
Mm-hmm.
Do you see any movement towards making this a more modern concept of identified with personal information rather than, in other words, a data set that identifies you by inspection? I can now see that data set identifies you, and therefore now it is privacy invasive.
Sorry, can you say a little bit more what you mean by identifying by inspection?
Yes, I can now see that this data set allows me to identify Harry, and that was not the intention of that data set before. No one expected that his spectacle wearing, choice of shirt, choice of footwear would in fact identify him in this particular group of people.
And the claim would be that so we are now somehow regulating this data set differently because
Data set becomes volatile and can change in real time, because obviously that's technically possible now. And at the point where it becomes able to identify Professor there, we'd add another classroom to the data set, which then would re-establish the privacy, because it's no longer unique to identify one individual.
right. Okay. So let me try it. So is your question then, how do we deal with the changes in our knowledge about re-identification? Is that the claim about?
My question was, can you see any move? Have you seen any move? Is there anything in the literature? Are there any discussions at policy level about trying to recast the idea of PII into some sort of more modern notion of what I'm calling, for the sake of an expression, IPI, or identified with personal information? This data set is identified with personal to Professor Harris. This is not. And if it is, and if that's a problem, I can re-establish privacy by relaxing one of the characteristics, which then re-establishes, in this case, the classroom next door, which then re-establishes cluster size to be anonymous.
Okay. Okay. So a couple of things. So to a certain extent, that is the story of the HIPAA privacy rule itself, right? Which is cast the way it is because of Latanya's earlier work on identifiability based upon zip code and the like, right? That was in some sense how the particular list of identifiers came to be, at least in part, in that particular situation. So now the question is, what do we move to, right? And one possibility is, as you've described, a kind of dynamic version of the same rule, right? But another possibility might be an entirely different kind of rule, right? One that tries to do a kind of risk assessment on an ongoing basis rather than trying to enumerate ahead of time what kinds of categories ought to be allowed or ought to be removed, right? And to a certain extent, that's some of the proposals about what to do about this problem are, I think, in the vein that you've described. So Paul Schwartz and Dan Solov have a model in which they try to put information on what they call a continuum of risk, right? No risk of identification and what they call perfectly identified individuals at the other end, and have this kind of continuum and try to understand where any given data set falls on this continuum and adjust the regulation accordingly, at least in the sense of having 3 buckets. Minimal risk, moderate risk, and high risk, basically. But what I guess I want to suggest is that by itself, I mean, the notion of risk might be OK here. I mean, it specifies something, right? But it might not be specific enough for the particular context in which we're actually interested in this particular, in these kinds of questions. That I'm not sure that this notion of a continuum of risk can be done without sensitivity to, again, risk of what, right? And that's my main claim here, is that this risk assessment has to be done understanding what the risk is that we're trying to classify against.
Take the direct marketing risk, that might pique your interest, or behavioral targeting.
Mm-hmm.
Well, I think you can define a societal risk as having a feeling of being observed, which maybe is not necessarily easy to square with autonomy or notions of democracy. If you take that as a particular threat, that's the risk we're trying to guard against, then it would seem that you could have some notion of probable replacement of PII, where actually it may well be the cluster sizes are quite small, surprisingly small, because in fact the protection is reasonably high. And actually it may be that the risk with the problem wrong around, actually targeting could be better rather than less good. Once you're certain that the k-anonymity property is sufficiently high or low to prevent identification.
Right. Okay. So I think that's right. Right. So in that particular context, it could be that that a low k would be that notion of k-anonymity in a low k would work just fine. Right. But I think that's quite specific to that again to the direct marketing kinds of situations. Right. And would, to my mind, be largely inapplicable when you look at something like medical records or the like. Right. Where again, the k could actually even be quite high, and nevertheless, there'd still be a quite significant risk of attribute disclosure in a way that's much more problematic in that context than it might be in the direct marketing case.
Agreed. Well, of course, the direct marketing one is hugely economically valuable.
Yes.
Which is not to say that one isn't.
Yeah. Yes. Yes. Yes.
Regarding the background information attacks
Mm-hmm.
and large data sets, so when you release anonymized data at one point, and then 2 years later you want somebody to release another data set, and one becomes the background information of another. So one, do you think there should be like central repository keeping track of all the public databases? Because otherwise I don't see how you can prevent such attack.
Right. So again, it depends on what the context actually is, right? So let's think about some specific contexts. Could we use this problem to solve the problem of medical records? So to my mind, I think the answer to that actually is probably no. That is to say, the background information attack was strong enough with respect to, and the potential privacy problems are potentially significant enough that, in fact, that probably counsels toward much more limited release of medical records. That is not going to be possible to release public anonymized medical records, right? That you're going to have data use agreements. You're going to have legal controls in addition to whatever privacy mechanisms you might want to create, right? And you're going to need to have things like one body that keeps track of all of the all of the bits of data that get released out of that database, right? In a for example, a differentially private query model where the central administrator holds on to the data and then keeps track of the privacy, how much of the privacy budget has been expended along the way, right? And so you're going to need solutions that look more like that. Are there situations in which we can imagine keeping track of the data in some centralized way? There probably are. None are coming to mind immediately, right? But it probably will depend on some specific kind of context in which that kind of keeping track, that there's some natural person, some natural focus for that kind of central record keeping, right? And B, the information is in some sense homogeneous enough that that kind of central information keeping makes sense, right? If your background information attack is, for example, based upon what kind of information is disclosed on Facebook, then there's no reasonable way to imagine dealing with it, and I think in those particular terms.
All right, cool.
Okay.
The banner.
Yeah. Thanks.